Welcome to Pacer Center's overview of the role of surrogate parents in special education, surrogate parent laws and guidelines. Partial funding for this video is provided by the Minnesota Department of Education. The federal law that makes available a free and appropriate public education to all eligible children with disabilities across this country is called the Individuals with Disabilities Education Act. The Individuals with Disabilities Education Act is often referred to as IDEA for short. Under IDEA, providing children with disabilities with a free and appropriate public education means that school districts are obligated to identify children with disabilities who may need special education and related services, evaluate children with disabilities to determine if they are eligible to receive special education and related services, and develop an appropriate educational placement and individualized education program for eligible children. The individualized education program is called an IEP for short. Providing children with disabilities with a free and appropriate public education requires a lot of decision making, and school districts are also obligated under IDEA to involve parents every step of the way in all these decisions. Because IDEA grants parents rights and responsibilities in the decisions that are made at every step of the special education process, if the parents of a child with a disability are unknown, unavailable, or not legally authorized to make educational decisions for the child, then a surrogate parent may serve the important role of acting as the child's parent in the special education process and advocating on the child's behalf. Under IDEA, parents of children with disabilities actively participate in decisions about their identification, evaluation, educational placement, and planning for how their children will be provided a free and appropriate public education. A free and appropriate public education is often referred to as FAPE for short. But parents and school districts do not always agree on these decisions. IDEA also grants parents the right to sign their consent or objection to any school district proposal or refusal of action at every step of the special education process. In these situations, IDEA also provides parents with dispute resolution options that support parents and school districts in resolving their disagreements. The role of the parent is incredibly important in advocating for a child's right to FAPE under IDEA. Every child with a known or suspected disability needs a parent to serve in this role, which is why IDEA includes guidelines for the assignment of surrogate parents to children with disabilities who need them. Due to the important role of the parent in the special education process, IDEA clearly defines what parent means. IDEA regulations explain who can represent a child with a known or suspected disability as the parent in the special education process. Under IDEA, for most children, their biological or adoptive parent fulfills the role of parent in the special education process. In some cases, a foster parent may serve in this role, but only if certain conditions are met. First of all, this is only possible if the biological or adoptive parents have lost their legal authority to make educational decisions for their child. Also, the foster parent must be willing and able to act as the child's parent in the special education process. And finally, the foster parent can only take on this role if no conflict of interest would arise that would prevent them from advocating effectively for the child. Under IDEA, when a child is placed in foster care, the biological or adoptive parent can continue to act as the parent in the special education process and advocate for their child's right to FAPE, as long as they still have the legal authority to make educational decisions for their child. IDEA also recognizes others who can represent a child with a known or suspected disability and act as their parent in the special education process. Some children have a guardian who is generally authorized to act as the parent or authorized to make educational decisions. It is important to note, however, that if the child is a ward of the state, IDEA prohibits the state from acting as the parent in the special education process. Other children have someone in their life who is legally responsible for their welfare, or they live with someone who is acting in the place of their biological or adoptive parent. This is typically a grandparent, a step-parent, an aunt or uncle, or another person in their family. Under IDEA, they can take on the role of parent in the special education process. Finally, IDEA recognizes that some children need a surrogate parent to take on the role of their parent in the special education process. IDEA charges school districts with assigning a surrogate parent to a child with a known or suspected disability in very specific circumstances, which we're going to review next. Under IDEA, school districts must assign a surrogate parent when no parent can be identified. In other words, the parent is unknown. Also, school districts must assign a surrogate parent if they cannot locate a parent after making reasonable efforts to do so. In other words, the parent is unavailable. In the state of Minnesota, reasonable efforts to locate a parent are defined in the law as including documented phone calls, certified letters with return receipts, and visits to the parent's last known address. For children with known or suspected disabilities whose parents are unknown or unavailable, IDEA requires the school district to ensure that the rights of the child are protected by moving forward with the assignment of a surrogate parent to the child. Under IDEA, other circumstances where school districts must assign a surrogate parent to a child with a known or suspected disability include when the child is a ward of the state. The state cannot act as the parent in the special education process for any child who is a ward of the state under state law. In Minnesota, a child is considered a ward of the state when a court order has transferred guardianship and the legal custody of the child to the Commissioner of Human Services. When a child becomes a ward of the state, the judge who is overseeing the child's case may appoint a surrogate parent for the child. If not, this responsibility falls to the school district. School districts must also assign a surrogate parent to a child who is an unaccompanied homeless youth as defined in the McKinney-Vento Homeless Assistance Act. This federal law states the term unaccompanied youth includes a homeless child or youth not in the physical custody of a parent or guardian. Finally, in Minnesota, A parent can request in writing that the school district appoint a surrogate parent to represent and advocate for their child in the special education process. The parent can also revoke their request in writing at any time. For example, a parent who becomes seriously ill could request in writing that the school district appoint a surrogate parent to make educational decisions and protect their child's right to FAPE. When the parent recovers from their illness and is in good health again, the parent could then revoke their request in writing and take over once more as their child's advocate in the special education process. To review, if the parents of a child with a known or suspected disability are unknown or unavailable, or if the child is a ward of the state, or if the child is an unaccompanied homeless youth, or if the parent requests in writing that a surrogate parent be appointed for their child. In all these cases, the school district must appoint a surrogate parent to represent the child in the special education process and advocate for the child's right to FAPE. IDEA states, the state education agency must make reasonable efforts to ensure the assignment of a surrogate parent not more than 30 days after a public agency determines that the child needs a surrogate parent. The public agency responsible for appointing a surrogate parent for a child with a known or suspected disability is usually the school district where the child resides, where their foster home is located, or where they are receiving care and treatment. In the state of Minnesota, the only exception to a school district having responsibility for appointing a surrogate parent is when a student is placed in a juvenile correctional facility, in which case the Department of Corrections is responsible for providing FAPE and following the IDEA requirement to appoint a surrogate parent for any youth in the facility who need one. IDEA establishes 3 criteria for school districts to use in the selection of surrogate parents. The first criterion is that a surrogate parent is not an employee of the state education agency, the school district, or any other agency involved in the education or care of the child. For example, a child's county caseworker could not be selected as the child's surrogate parent. In some cases, a guardian ad litem may serve as a child surrogate parent. In Minnesota, a guardian ad litem is appointed by the court to represent the best interest of a child in a family or juvenile court proceeding. If a child is a ward of the state, the court overseeing the child's case could appoint the guardian ad litem as a surrogate parent if the guardian ad litem meets all 3 IDEA criteria. Similarly, a school district could appoint a child's guardian ad litem as a surrogate parent if the guardian ad litem meets all 3 IDEA criteria. An important exception to the first criterion is that IDEA does allow for appropriate staff of emergency shelters, transitional shelters, independent living programs, and street outreach programs to be appointed as temporary surrogate parents for unaccompanied homeless youth until the school district can appoint a surrogate parent who is not involved in the child's care. The second criterion in IDEA for selecting a surrogate parent is that a surrogate parent has no personal or professional interest that conflicts with the interests of the child. And the third criterion is that a surrogate parent has knowledge and skills that ensure adequate representation of the child. In Minnesota, school districts are required to train surrogate parents in the knowledge and skills necessary to adequately represent a child who needs a surrogate parent, or appoint a surrogate parent who already has the knowledge and skills to do so. Minnesota requires that every surrogate parent has knowledge of state and federal requirements, knowledge of school district structure and procedures, an understanding of the nature of the student's disability and needs, and the ability to effectively advocate for an appropriate educational program for the student. Serving a child with a known or suspected disability as their surrogate parent takes time and dedicated effort. In Minnesota, the school board can remove a surrogate parent by majority vote if they fail to carry out their responsibilities in the team meeting and IEP process, if a conflict of interest arises, if they take actions that threaten the well-being of the student assigned to them, if they fail to represent the student, or if the student no longer needs special education and related services. In these cases, the school board must notify the surrogate parent of the reasons for the proposed removal and the time and place of the meeting where the vote will be taken. Also, the surrogate parent must be given an opportunity to be heard. Thank you for taking time with Pacer Center to review the federal and Minnesota laws and guidelines that support the important role of surrogate parents in special education. We hope this information is helpful to you. For individual assistance with questions about this topic, reach out to a Pacer Parent Advocate by calling 952-838-9000 or by sending an email to pacer@pacer.org. Pacer Center is proud to be Minnesota's parent training and information center. We welcome you to connect with us again soon.